I'm Teresa Keller. Welcome to this conversation. My guest today is Christopher Johnson, an attorney in private practice in Abingdon, the second guest in a series on free press. Mr. Johnson was appointed by a judge in Smith County to represent David Huff, who runs a YouTube site called Hilltop News. To begin, I'm going to run an edited clip of Mr. Huff's arrest at a Saltville Town Council meeting on July the 9th, 2024. He was charged with disorderly conduct. Huff was recording the incident with his phone, and it's unclear that the police officer was aware of the recording in process. Here's how it happened.
I'm press.
You're not a member of legitimate press.
How do you get a badge for the press? Who do you get it from?
You're not employed by them.
You gotta be employed by
Yeah, I've got more subscribers than you. I've got a press pass right here.
That offends me.
Look, I'm going to video this thing for my news channel, and I'm press. The First Amendment gives me the right to
If that's the case, everybody here is
independent
the
press.
First Amendment.
They can,
covered by the
if they
press.
want a video, they can.
Video, we're gonna video it back there.
I'm videoing with the press. That's where they're at. If I move, they should move.
They're the
Right here's it says press.
standing right there, takes them to jail.
For what?
Disorderly conduct. I'm asking you.
What am I doing?
Listen,
What am I doing?
you're sitting somewhere you're not designated to sit.
I've got my badge. The First Amendment, you swore an oath
Where'd you
to.
get that badge?
I made it.
Well, I'm telling you right now, you're fixing to go to jail for
Tell-
disorderly. You're not press. Get back in the regular gallery for everybody else.
I was just wanting to
Let's
get
go. We're gonna
advice
walk you out
from you.
nice. Let's go. You're going to jail for disorderly conduct. Let's go.
For what?
Disorderly conduct. Get up and stay. Hands behind the back.
We are back from hearing the clip of David Huff's arrest for disorderly conduct. My guest today is Christopher Johnson, and he's going to shed some insight onto this issue of that we're calling a free speech, free press issue, even though the charge was disorderly conduct. Welcome, Christopher Johnson, to this conversation.
Thank you very much for having me.
Well, we're looking forward to clarification on this complex issue. First of all, let's just start simple. You were court appointed to represent David Huff. What does that mean, and how did that happen?
People that are charged with criminal offenses, which carry a jail sentence, are entitled to a court-appointed attorney, depending on their income level and their assets. And I guess Mr. Huff qualified as an indigent criminal defendant, and so therefore the court appointed me.
We just played the clip of the arrest. When you first saw that clip or learned about the case, what were your thoughts?
My thoughts were immediately that this is a First Amendment issue. This man was holding himself out to be press, that the government, through its agent, decided that he was not. The questions were abound about how does one get the credentials or whatnot to be at the table where Mr. Huff wasn't supposed to be, evidently. And of course, I found out that there really weren't any. There's no guidelines set up. There was no process by which to be given credentials. And so at that point, this is a classic case of an ad hoc kind of decision on the part of the government to decide who is a press and who's not, without any. It's arbitrary and capricious, is what my argument would have been.
Let's trace the case first, and then we'll get back to the bigger First Amendment issues. So you go to a first hearing with him. Had you met him before the hearing?
I had spoken with him on the phone. He was very interested in his own defense, which I always appreciate that. I thought it was a fairly straightforward case. But the first time we met in person was at that very first court hearing, yes.
He's arraigned. He's presented with the charges. He gets a court-appointed attorney. That's you. And you
Correct.
show up at a second hearing with him. What happened there?
I don't really wish to get into a whole lot of details. It's confidential, I guess. But what's not confidential is that they moved for a continuance at that first hearing. I believe it was over my objection, but the way the local rules are is such that either side, whether it be the defendant or the Commonwealth, are more or less entitled to one continuance.
So you show up, you're ready to defend him, but the case gets continued, which means delayed.
Correct.
Then Is the next hearing in October when the case was finalized?
Yes, ma'am. That was the next hearing date. For reasons that I'm not going to get into, the Commonwealth, I think judiciously, decided to enter an order of null pros or nolle proseque, if I may, which is basically a way for them to dismiss the case. Technically, the Commonwealth could bring this back within 1 year of them initiating the case of his arrest. In misdemeanor cases, I've never seen it.
All right, I understand and respect that you will only talk about what was visible in open court and you don't want to go into anything behind the scenes, but one might assume that there had been some negotiation, that you'd been doing some work behind the scenes, that in court the judge says null pros on this case, which is kind of like, you can correct me on this, it's kind of like saying we table it. It's still there in the background, but nothing's going to happen.
That's correct. And with the statute of limitations being such as they are in the Commonwealth of Virginia, after 1 year, then they cannot be brought back in any event.
So you're saying this is not a disorderly conduct case. It really is a First Amendment case because he's saying I'm a member of the press. That's a constitutional issue. You have a right in this constitution in this country to have a free press. And someone said in the clip that this table where he wanted to sit was reserved for press. He said everybody's in a journal. Everybody can be a journalist. And this voice in the background says, you get your press credentials from the state police. Huff says, no, you don't. I am independent press. Here's my identification, and it's a card that he has made. Who's correct?
As far as the state police issuing press credentials for the Saltville Town Hall, that's a new one to me. I don't know that that's correct at all. Can somebody just make their own press credentials and then that makes them press? I don't necessarily buy that one either. I took a First Amendment class in law school, and I actually, in preparation of this interview, kind of flipped through, and the definition of press is in this gigantic, 300-page book full of case law, doesn't define press, really. There is a footnote in one case, and I had it, but it was a 1974 case, and Justice Berger, who authored the opinion, said basically that the press is not limited to, this is 1974, not limited to just print. It's also by electronic means, which I found to be remarkable that, before the internet, they were already laid out the groundwork that the press is I think, according to the Supreme Court, a broad definition. And as such, I guess anybody could be press. You have Thomas Paine handing out pamphlets. Well, he wasn't the New York Times or anything like that. Much of our First Amendment jurisprudence goes back to that person on the street corner handing out pamphlets.
You might want to just remind people exactly what Thomas Paine did.
Well, Thomas Paine, in the days leading up to the Revolution and in the times afterwards, would print these things called broadsides. And basically what they were is like just a one-page, usually scathing opinion piece about, oftentimes criticizing the government. Obviously, before the American Revolution or during the American Revolution, he was criticizing the crown. All the founders, thought, hey, this guy's great. We love that he's on our side. And of course, after we got our independence from England, he starts criticizing the powers that be here in America. And then, they didn't like him very much because he's criticizing them.
He is considered to be responsible for support for the revolution to some extent just by passing out these pamphlets.
Yes, indeed. Again, these scathing, what they refer to as broadsides. He wasn't a nice guy. He was very critical, and one could say that he helped stir the passions that led to patriots participating in the American Revolution.
Our point being here that he was not a beloved person. David Huff is not a beloved person, and in Saltville and in Smith County. But also another claim that was made during that clip is that to be press, you have to be employed by a major media outlet. What say you on that, Attorney Chris Johnson?
Well, again, according to the cases I've read from the Supreme Court, specifically addressing First Amendment jurisprudence and just history in itself, would say no, that's inaccurate, that's too narrow a definition of press is. Let's go back to the language of the First Amendment of the United States, and that is that the government shall make no law that impedes either speech or the press. There's threat. You can't yell fire in a crowded theater unless there's an actual fire there. That's the one exception. But you can't, through speech, cause people to panic and trample one another. And so there's reasonable, curtailments to that First Amendment, what it says in the Constitution in black and white, that the government shall make no law. The founders, I think, wanted the press to be broadly defined. What it's all about is the marketplace of ideas, okay? We live purportedly in a free society wherein the marketplace of ideas is paramount. You don't want to limit it. You want it to expand. Counter bad speech is with good speech, or untruths with truths. It's not to just limit. The government is not there to pick one side or the other and limit the speech of one side or the other. And I guess in a broader context of what we're talking about is that the government doesn't get to decide who's press and who's not. Just because he doesn't work for the Washington Post doesn't mean that he's not press necessarily.
And that the philosophy is fascinating, because we're not saying only truthful, kind, polite speech is protected, or the Constitution is not saying that. The concept is let everybody have a voice, and citizens who should be educated will be able to sort out the difference between what's true and what's false. But what David Huff is representing, or the point he's trying to make, is that the government doesn't get to say that I'm not press. The town of Saltville doesn't get to say I'm not press. What is the principle that he's defining? Why is it dangerous for the government to say who and who is not press?
You're limiting. If Mr. Huff isn't allowed to be in that room, then he can't report on what happened in that room. And therefore, the government is then limiting all of us as consumers of information and participants in the marketplace of idea. Basically, they're limiting that, and it's a violation of not only his rights, but to a certain extent, all of our rights, because the government is choosing who's press and who's not. That's just, it flies in the face of the whole idea of the purpose of a freedom of press or a freedom of speech.
In this case, Saltville is the government, and somehow Saltville had some kind of concept of who was allowed to be at that press table and who was not. But asked what are the requirements, there were no requirements. There was no application process. There was no, here are the standards of who we're going to consider to be press. So is the issue with Saltville?
For Mr. Huff, yes, certainly. When they decide, without there being any kind of guidelines as far as getting credentials to sit at that table, I mean, there's certainly, and I think you pointed that out with Mr. Huff when you had your interview with him, as a practical matter, I mean, they can't just shove everyone and their little brother who claims to be press in that room or had them sit at that table. There has to be, as a practical matter, some limitations as to, for space purposes, if nothing else. But they have to have some guidelines beforehand to say after the fact that, okay, you're press, you're not press, you're press. That is, that's arbitrary and capricious. And while governments have a lot of leeway to make laws, virtually all laws are subject to that limitation, that you cannot just make laws for no reason or have them made on an ad hoc basis, just kind of like based on feeling or whatever. There has to be, some reason that the government would put forth a limitation on that. Like, if there was a thought that, there's too many people at this table, they need to think ahead of time, basically, and have like a lottery maybe for people that claim to be press or something along those lines. the thought of them just deciding without any guidelines and without any real reasonable explanation, that they're going to decide who's president, who's not, again, then that's arbitrary and capricious, and that's why we are a country of laws. Okay, in the big picture, the government just doesn't get to decide it whenever they want to on any given subject. They have to. There has to be reason.
So, unless there's some standard in advance, David Huff is right. So, it appears that David Huff is right that without advanced credentialing, there should be no press table. And in that case, everybody in there can take their phones and record. Everybody is press.
That's the First Amendment according to Chris Johnson. Okay. I think other people would have other opinions. Certainly, throughout the history of the Supreme Court, there have been certain justices that are more absolutist in their finding that the government shall make no law. And then there are certain other jurists who would curtail that to an extent that I would personally find unacceptable. But the way I read the law, and again, I'm not a justice, I'm just a lawyer here, but the way I read the law is that David Huff is right.
Let's move to the real umbrella question about free speech. David Huff does not deny being rude, obnoxious, wanting to get under the skin of these public officials. The First Amendment protects obnoxious speech, but it really gets tricky when we get into racist, anti-Semitic, and false speech. What does the First Amendment say about that?
Well, geez, this gets, basically, broadly speaking, opinions are protected. And so if I were to say something that, in my opinion, preface it in that nature, I can say virtually anything. Okay. Now, the Supreme Court, again, rightly or wrongly, however you want to look at it, has decided that, things such as hate speech should be regulated, and that there are limited protections for hate speech, or that fighting words, for instance, that's not protected speech, and that there should be limitations on that. And of course, what are fighting words? Well, you go down a whole rabbit hole. We'd have to have a 10-hour subject on that. And what is hate speech? Why similar kind of what's hateful to me may not be hateful to you. It's somewhat problematic, but it's not without reason. I understand the basis of it. So opinions are generally protected no matter what. Falsehoods are not protected. And that's where you get into issues regarding libel and things of that nature, where newspapers are sued by individuals because they have knowingly and intentionally and maliciously printed false things about them. So it's not protected speech. And I think that that's probably a good thing, that we don't need to protect somebody who's just outright lying and causing harm needlessly. I can understand that. And I guess when we're talking about the press and how that fits in, is that I don't care who you watch, whether it's MSNBC, Fox News, anything in between. What we're fed on these 24-hour cycles is glimpses of the news in a matrix that is all opinion. And so they can get away with saying a whole lot of stuff because this is just opinion. We're not really the news. And as a matter of fact, I think Fox News famously in the last 10 years, during the pleadings in a lawsuit, had made that same thing. It's like, this is just opinion. We're not, I forgot whether it was the Hannity show. Well, it was one of the shows. But I think they're all doing us a disservice, to be honest with you, by hiding behind that.
Chris, this is just for my personal satisfaction to ask this question. In my interview with David Huff, and we're going from the sublime and the theoretical to the simplistic, I guess, But in my interview with David, I had watched one of his clips where he walked into the work area of a garage, not the reception area. He walked into the work area with a camera rolling and accosted someone who was a public official but was at work doing his work in this garage. He said that that was not trespassing. Could that man have charged him with trespassing?
No, I listened to that part of the interview very carefully, and Mr. Huff is 100% correct. If they had put up signs that said, no trespassing, then if if he ignored those signs and went on that property anyway, then that would clearly be trespassing. Or if he had been notified in advance, hey, Mr. Huff, you're not allowed on this property, and he goes on the property anyway, that's trespassing.
No kidding.
If he remained on the property after being asked to leave, that would be trespassing. But absent those things, then he is not trespassing.
He knew that. To me, the analogy was, could he walk in my front door if it's unlocked and he's not doing anything wrong until I tell him to leave?
You're talking about a private residence versus a business. If you walked in the front door, he runs the risk of that's like breaking and entering. Like that's a whole different kind of level. I think at your own I'd have to look at the law more carefully. I've never had a case wherein somebody's charged with trespassing in the defense inside someone else's house, and the defense is, well, they never said I can't come in here. I think that by virtue of the door being closed, and it being a private residence, I think that would suffice to say that the public is put on notice that you can't just barge in here.
Let's make it different. I'm stubborn. What if he just walks onto my yard?
Okay. Yeah, then I would say that's not trespassing absent there being signs saying
No
otherwise.
kidding. Wow. Shows you what I know. But anyway, that's very interesting. So thank you, Chris Johnson, attorney in Abingdon, Virginia, for talking to us about this complicated case. And let's go back from the smaller issues and my ignorance to the bigger issues. How would you like to conclude this in what we all should take away from this case of David Huff's arrest?
David Huff. Okay. Let's back up. And it's not just David Huff. Again, all of our what we call First Amendment heroes are not likable people. Okay. They are, by and large, a lot of them we would not agree with. Okay. But the government's job is to protect the marketplace of ideas, not to determine what goes into the marketplace of ideas. The government's job in the First Amendment is to protect the David Huffs of the world and the Thomas Paines of the world that are critical of the government. The United States Constitution, except for one amendment, is limiting the power of the government. And I think that we've somehow we've lost track of that. People are like, they love the Constitution and everything, but they don't really understand the fundamental thing, that is that the Constitution limits the power of the government in favor of the people, period, except for the 13th Amendment, which specifically says that people cannot own slaves. But everything else is a limitation on the government over the people. And so, when we look at the First Amendment in that context, it's incumbent upon the government, again, not to limit speech, but to enable it, to protect people and their opinions. And, no matter how vulgar they may be to some people. And so, in this day and age, there's a rise of authoritarianism all over the world, and some would argue here in the United States. I think now more than ever, we really need to be aware of what our rights are as contributors and participants in the marketplace of ideas, and to not let the government curtail our rights. It's very important that we speak up for ourselves, and in that regard, David Huff, God love him, for doing what he's doing. Again, I don't necessarily agree with everything he has to say, but I know that he comes at it from a place of wanting to defend the Constitution, of understanding his rights and wanting to exercise those rights. And I think that that's something we should all do a little bit more, in my opinion. Mr. Huff and I have a similar kind of back. My dad was a career Marine. I know that he put his life on the line in defense of our country. And so I guess, and David Huff made mention that his dad is a Green Beret, and I think he might have died in combat or shortly thereafter as a result of something. But the point is that the sacrifices that our both of our fathers made, I guess have an impact on the way we view the government and what our rights are as citizens and how important it is to exercise those rights. And so he and I kind of have a similar kind of broad view on what our responsibilities are as citizens.
We're going to leave it right there. Attorney Christopher Johnson, in practice in Abingdon, Virginia, who represented David Huff as a court-appointed attorney in his disorderly conduct charges for insisting that he sit at the press table in Saltville, Virginia town hall meeting. Thank you once again, Christopher Johnson.
My pleasure. Thank you.
I'd like to remind listeners that you can go to David Huff's YouTube site. It's called Hilltop News, operated by David Huff. You can hear on that site, or you can see on that site, the clip of his arrest. You can also go to the archives of this show and hear my interview with David Huff, and you will also find today's interview there with Christopher Johnson. To find that site, search for WEHC, This Conversation. There will also be a link to the clip of the arrest at that site. This has been the second part in my series on free press and free speech. Part 3 will be an interview with a student journalist who, bottom line, had her windshield busted based on coverage of an issue of free speech. You can find this conversation Wednesday at 6, Sunday at 2 here on 90.7 Emory and on 90.5 Wise. And again, you can find the archives, WEHC, This Conversation. Thanks again to the listeners. Thanks again to Chris Johnson, and we'll see you next time.